Thank you for giving the opportunity to present the profile of today's speaker, Sri C.A. Anil Goyal Garu. Sri C.A. Anil Goyal is a founder and chairman of AAA Insolvency Professionals LLP. It is one of the first two insolvency professional entity recognized by Insolvency and Bankruptcy Board of India. He was a member of advisory committee of IPA of ICA till March 2020. He has been co-chairman of ASSOCHAM National Council for Insolvency and Bankruptcy till March 2021. He was a member of working group established by IBBI for implementation of individual bankruptcy in India. He was also a member for SEBI group as constituted by IBBI for interaction with the SEBI, NSE and BSE for seeking concessions for companies under insolvency process. He was a faculty for awareness program launched at the instance of CBDT and IBBI for tax authorities and deliberating on tax authorities vice versa IBC. He was a faculty for spreading awareness among SDRT members and officials on insolvency and bankruptcy of professional guarantors. He is a regular faculty at IACA for the first batch of graduate insolvency program by IBBI. Sri C.A. Anil Goyal is a regular speaker at various forums and webinars on insolvency and bankruptcy law, valuation and management of stressed assets under SURFACI or otherwise through restructuring of debt. He is a regular speaker at workshops organized by IBBI, IPS of ICA, ICSI and ICMA, ASSOCHAM, CAA, PhD, IICA, FICCI, and have given various talks at banks and financial institutions besides being faculty at training workshop organized by IBBI for IPs and pre-registration education course for new insolvency professionals by IPS, SBI Academy, IECA for GIP, etc. Professional experience. Sri C.A. Anil Goyal is also the most experienced IP in the country as he has concluded 15 assignments in his name and is presently acting as a liquidator in 10 companies. Some of the known names are REA Agro Limited, Rotomac Group of Companies, LML Limited, Amrapali Group, Lanco Group of Companies, Nirav Modi Group Companies, Visa Power, Varsana Ispat, etc., either in his name or in the name of his partners. He is the founder of AAA Insolvency Professionals LLP, the largest insolvency professionals entity, IPE, in the country in terms of handling more than 190 assignments as IRP or RP or liquidator collectively in the names of all the partners of AAA Insolvency Professionals LLP, which he is supervising and providing all the support services, including legal support, including 45 assignments of liquidation process. Largest number of designated partners, that is 32, and 12 associated partners, and still selecting for some more partners at different locations. Largest number of human resources, that is 300 plus, working full-time for insolvency and SURFACI practice. Maximum locations covered as offices and partners are located at New Delhi, Mumbai, Kolkata, Bangalore, Hyderabad, Raipur, Ahmedabad, Chennai, Kochi, Bhubaneswar, Ludhiana, Jaipur, Pune and Kanpur. Sri C.A. Anil Goyal is also the founder and chairman of AAA Capital Services Private Limited, a company engaged in profession of resolution and enforcement agents under SURFACI Act, having operation across 20 states of the country. AAA CS is also the largest company in the country under this domain, having handled more than 25,000 plus cases under SURFACI Act and have taken more than 4,000 physical possessions of secured assets. Sri C.A. Anil Goyal is also non-executive chairman of AAA Valuation Professionals LLP, an IBBI recognized registered valued entity for all the asset classes. Sri C.A. Anil Goyal is a senior partner of Messrs. AAAG and Co. LLP, Chartered Accountants, a mid-level CA firm engaged in raising funds, structuring, restructuring, rehabilitation, and have handled more than 1,000 such cases besides handling audit, accounting, compliances of GST, income tax, Companies Act, FEMA, etc. for more than 200 business families and their entities. With this brief profile, I am inviting Sri C.A. Anil Goyal Garu to take his session on IBB refreshment course. Thank you, sir. Thank you very much.
Thank you, Amarnath. Thank you very much. But then when I shared my profile on the email, I said that this is a little longer and you may choose some of the words which you would like to deliver.
Oh, sir, when a lot of achievements are there, we have to intimate the audience, sir.
No, I believe you actually have read the entire one. Anyway, I don't mind that. And I definitely would like to motivate all my professional colleagues. My greetings to Mr. Srinivas Rao. And I also understand that CA Shangal Reddy, who is the regional council member, is also present. I'm not sure whether my friend Hansraj Chug is present or not, but then he actually is a very close friend of mine.
Oh, he joined for the inaugural, sir. As a chief guest, he joined and inaugurated this 6 days program.
Okay. So my greetings to him also in absentia. And thank you very much for this opportunity. I would actually complimenting and congratulating all the participants today. And I can see the numbers are increasing. And it is not really important that you all should become insolvency professional. I'm not saying that this profession is not good. This profession will definitely have the edge over other other professions, at least for the coming 30, 40 years, till the time the competition increases a lot, because still there is no competition. The PIRP, the individual insolvency, everything would add to the business opportunities, professional opportunities to all the professional colleagues. The otherwise also participating into this kind of awareness programs that would actually help in doing other assignments like restructuring under PIRP, like the forensic audit under the IBC, like claim verification under IBC. So the objective is, I believe, not everyone is here to appear in the examination, but that is also a very important aspect. What I wanted to say even before this program started, that for even auditing, this subject is important. For each and every professional assignment, the knowledge of insolvency law, when it will be applicable to all individuals, partnership firms, proprietorship firms, it would be very important for all professionals to know the details of this law. So my congratulations to all the participants for joining this program. I, like Mr. G.K. Raju has given me this program that you actually have to speak on the Supreme Court orders and some of the High Court orders. So I definitely couldn't prepare any detailed PPT, but yes, a very, very basic PPT that I have prepared in the last few hours. I would like to share that screen with all of you. So first of all, let me say that this is the kind of syllabus that I have seen for the purpose of appearing in the limited insolvency examination of IBBI. So this syllabus is there on the website of IBBI. So there are 17 Supreme Court judgments which are in syllabus, and there are 9 High Court judgments. And because the time is also restricted, so we would only be focusing on these judgments which are there in the syllabus. My PPT may have some other judgments also, but I would, unless there is a question on those PPTs, I would like to skip, or in case the audience in participants would be interested, that would be all right to me. So this, we would actually keep seeing the kind of, we have this syllabus with us. So these are important Supreme Court orders. There is no order by which I have just prepared quickly this PPT, and I would just see this. All these orders are really important for all the participants. So this is the State Bank of India versus Accord Life Spec Private Limited, and this is February 2020 order. In this case, the Supreme Court relied upon Maharashtra Seamless Limited versus Padmanabhan Venkatesh and others, wherein it was held that a resolution plan may not necessarily provide for a value. So this is the like in normal parlance, it has already been thought, and the committee of creditor is already kind of they were practicing that if a resolution plan is offering a value which is below the liquidation value as assessed by registered valuers under regulation 35 of CIRP regulations, that resolution plan cannot be accepted. So this was the practice which was going on. So this particular order with Maharashtra Seamless Limited versus Padmanabhan Venkatesh and then State Bank of India versus Accord Life Spec, this particular order clarified, although it was also clarified in ArcelorMittal India, it is reiterated that the adjudicating authority is vested with the limited judicial review. The adjudicating authority is vested with the judicial limited review. So the NCLT doesn't have powers to modify the resolution plan. So in case the resolution plan is below the liquidation value, the amount which is offered is below the liquidation value, so that actually can be accepted. There is no bar in the law to accept a resolution plan which is offering an amount which is less than the liquidation value. So that is something which is clarified in this order. Although there is no such regulation, there is no such section which says that the resolution plan cannot be accepted below the liquidation value. It is all based on the commercial wisdom of the committee of creditors. It is all based on their own assessment of the valuation done by the registered valuers. They might even see that the valuation done by the registered valuers is very high and they may not recover that much of amount. So the most important is that the company should be kept as a going concern, and as against this particular objective, the other objectives are short-term objective, like the recovery of the amount. So this order, I believe there is no confusion about this order. So number one, see there is an echo. There is an echo in the voice. I don't know whether it is because of me or because of somebody else is working on two devices. So it normally happens when somebody is actually logged in with two devices. Now it is okay. Now I think it is corrected.
Sir, sorry to interrupt you, sir. Can you be a bit louder, sir?
Yes, I can. So I can actually keep my mic closer to my mouth. Is it better now?
Yes, sir.
Okay. So so the first.
Sir, sorry for the interruption. Nandiraju Mukteshwar Rao joined two devices. Ravi.
Sir, yes, sir.
Mukteshwar Rao.
Yeah, I am checking, sir.
Yeah, please.
So okay. So see the very first judgment, it says that the resolution plan can be accepted, which is offering a value which is lower than the liquidation value. Two, that the adjudicating authority is vested with the limited judicial review powers. Three, that the adjudicating authority would not have powers to amend a resolution plan of their own unless the RA gives a kind of a concurrence. So the two orders, one is the Maharashtra Seamless Limited versus Padmanabhan Venkatesh, and the other is the State Bank of India versus Accord Life Spec Private Limited. Now, the second, which is very important, is Anuj Jain, which is who is an interim resolution professional versus Axis Bank, and this particular order deals with the preferential transactions under Section 43 of the Code. There are some rules which is provided by this order by the Supreme Court, and the two things that they actually deal with is what is a preferential transaction, and secondly, they also held that if a company is extending a collateral security which is owned by him to secure the credit facilities granted to another company, maybe subsidiary company or maybe an associate concern or maybe a holding company. So property belongs to a company in the group and the loan is taken by another company. So one company is giving its own property to the other company's credit facilities. The court says that it would not be considered as financial debt. So it would be considered as a operational debt, but secured. I mean, this is very important, that secured operational debt, secured operational creditor has the same priority as the secured financial creditor. Secured operational creditor has the same priority as the secured financial creditor, because the wording mentioned in Section 53 is only secured creditor. It does not differentiate between financial creditor, financial secured creditor, or operational secured creditor. So this particular judgment says that this party who has not taken any loan, neither granted any loan, simply offered a collateral security to secure the credit facilities of an associate concern, subsidiary company or a holding company, would not be a financial creditor, but would be a operational creditor, but secured. The second important part is the preferential transactions. For determination of preferential transactions, there are some basic parameters that has to be established. And the first is the look back period. Look back period is provided in Section 43 as 2 years for related parties and 1 year for unrelated party. So this has to be calculated from the date of the CIRP. So then the court says that the next step would be to determine whether there has been a transfer of property or transfer of an interest of the CD to somebody, and also that transfer must be to a creditor. So the preferential transaction only qualify Section 43 if the payment or the property has been given to an existing creditor. The third is that the beneficiary is a creditor or a grantor or a surety in the capacity of the CD. So the money or the asset must have been transferred, or the property must have been transferred to a creditor or a grantor or a surety. Thereafter, that we actually have to analyze whether the transaction which is made, is it made to a financial debt or an operational debt, and whether the said transfer of the property puts one person into a beneficial position. Now, Section 53 says that the first priority would be with the secured creditor, and then it would be unsecured and then operational creditor. Now, if an operational creditor is paid an amount which is not a regular course of the business, and some money is paid to an operational creditor, to an old operational creditor, which is not related to the keeping the company as a going concern, which is not related to the regular normal course of business, then it would be considered that instead of giving it to a secured creditor, the money has been paid to an operational creditor. That's a preferential transaction, and the money is recoverable from the beneficiary. So based on this discussions, the transaction between the CD, and it was held that this is a preferential transaction. And this issue was that as I already said, that this will be a secured creditor, but it would not be a financial creditor. So the secured creditor would also have the same priority as the secured financial creditor would have. So two things in this order in Anuj Jain, IRP versus Axis Bank. One, what are the basic factors to determine a transaction as preferential transaction under section 43? Second, the simply offering a collateral security to secure the credit facilities of other company would not mean that it is a financial debt. It will simply be a secured creditor, and it will be considered as a secured operational creditor. Going forward, another judgment, which is Rajendra K. Bhuta versus Maharashtra Housing Development and others. This is regarding the moratorium under section 14(1)(d) of the code. The fact says that this corporate debtor entered into a tripartite joint development agreement with respect to development of a land. One part was one side was the Maharashtra housing development, and the other part was the CD, and there was a joint development agreement. The CD was supposed to develop the land, and the revenues or the space would be shared between the CD and Mahada. When this insolvency started, Mahada served a termination notice, and in that termination, 30 days termination notice, and then all these appeals started. The Supreme Court held in this case that this cannot be, the corporate debtor cannot take the advantage of moratorium section 14, as the owner of the land would remain the owner of the land, and the section 14 would not work against the interest of an owner. Against the interest of a third party, it would not work. So the CD only has a license to make development on the land of the party of the contract, which creates a beneficial interest in favor of the CD and does not amount to occupy or possession. Therefore, the termination notice would not fall under the ambit of moratorium. In fact, this Mahada judgment has been used by various other land owners like Noida, like state-owned land agencies, like other land owners. So to my understanding, this only talks about section 14, which is a moratorium section. It doesn't talk about whether this share of Mahada would be an operational creditor, whether the Mahada would be a financial creditor, or it would be an operational creditor, whether they file their claim or they don't file their claim, how Mahada type of organizations would be considered in resolution plan. That is not something which is attended by this order. It only talks about that section 14 cannot be used to say that this license cannot be cancelled. However, I think this particular order, in case we see on 28th of December 2019, amendment was also made in section 14, and based on that amendment, the no license etc. would be cancelled during moratorium. And I am not sure whether that particular amendment was used in this order. I'm not sure about it. However, the present scenario is that section 14 is also applicable to licenses and other permissions granted by state, granted by central government or local authorities.
Sorry to intervene.
Yes, please.
This is Sridharan from Chennai. Quick one, when you are talking about the moratorium, what is the timelines which we are talking about here, and why the moratorium was kind of crux in this issue?
No, I think the moratorium timeline is only after the start of CIRP. Moratorium is only related to the commencement of CIRP, not before that. Moratorium is not something which actually can be available as a protection to the company. It is only available as a protection to the company after the CIRP is started.
Okay.
Yeah.
All right, got it. Thank you, sir. Thank you.
Yeah,
Thank you.
yeah. Now coming to the Embassy Property Development Private Limited versus State of Karnataka. In fact, this is also very important order. You know, when actually we talk about the preparation for the examination, the questions which will come will be having multiple choices. The English made in the questions and the answers, all those would be little confusing. I have learned this from Mr. G.K. Rao. He says that he call these kind of questions as landmine questions. So before we step on, landmine question means that before we step on any answer, you have to be very, very careful because there is a negative marking also. So consider each question as landmine question and step on the answer of A, B, C, D very, very carefully after understanding the question clearly. Now, this Embassy Property Development Private Limited is dealing with the multiple issues. One issue is whether the High Court can interfere with the orders passed by NCLT or NCLAT, and whether the High Court can use Article 227 to 26 of the Constitution of India. Secondly, whether the cases of fraud can be investigated by NCLT or NCLAT during proceedings initiated under the code. Now, primarily, this Embassy Property Development is a very important judgment because it actually says multiple things which has been used correctly and incorrectly by many benches. I'm saying correctly and incorrectly by many benches because based on this order, no, when it is written, first of all, it is written that the kind of lease which was granted, it was said that the corporate debtor had a mining lease granted by Karnataka government, and the CIRP was initiated. So the RP sent a letter to Karnataka government that the lease should be extended, which was denied by the government. And later on, an NCLT application was filed, and the denial letter of the Karnataka government was set aside by NCLT, and then appeal was filed before NCLAT, and that way the matter had gone to High Court and NCLAT. Now this appeal is before the Supreme Court, and Supreme Court clarified various things. Number one, the Supreme Court clarified that the jurisdiction of High Court under Article 226 by bypassing the statutory alternative remedy provided by a special statute. So the Supreme Court specifically again and again held that there is a distinction between the powers under Article 226 or 227 of the Constitution of India, and however that power can be used when there is no alternative remedy available under that special statute. Now, this is applicable to those cases also where some special statutes are there and there are special remedies available. For example, there is a special structure of filing appeals under the Income Tax Act. There is a special structure of filing appeals or finding remedies under various other acts. So all those things cannot be brought to NCLT forum, as the NCLT cannot be considered as super power court. So wherever there is a special such statute, that cannot come to the NCLT. It also says, so therefore the question of renewal of lease, that is a state government issue, and there is a special law for that, which is the MMDR Act 1957. And since there is a remedy available in that law, there is a structure available for filing appeals and for filing grievances. So those should have been used, and NCLT or NCLAT would not have power to do this. Then the further court says that the section 60 subsection 5 talks about the jurisdiction of NCLT, and that jurisdiction is it's a question of law or regarding the claims It also says that whenever this corporate debtor has to exercise a right that falls outside the purview of the code, it cannot take a bypass and go to NCLT for enforcement of such a right. And also in the given situation, it cannot take the recourse of Section 14 as it does not deal with the renewal of the lease. The second part of this, so in this particular case, the embassy property said that wherever the public law, in all the matters of public law, the matter cannot come to NCLT. So the jurisdiction of NCLT under Section 60 subsection 5 cannot be expanded to that great extent that all public law matters should also come to NCLT. Now see, when I studied public law and then I also studied private law, so I actually found that the public law is a matter where one side is any government, maybe state government or local authority or central government, and the other side may be any other person. And the private law is when there is a dispute between two private persons. So that's a private law. So based on this particular judgment, the various benches are now coming with orders that for recovery of money, where the applications are being filed by the RP or the liquidator, that is not under the jurisdiction of NCLT. Whereas in case we understand it correctly, this recovery of money or even the tenancy issues or even the issues of specific performance of a contract, all these are questions of private law. The private law is between two citizens of the country. So that can be handled by NCLT because there are various matters, there are various timelines, and the liquidator or the RP cannot be asked to go and file cases of recovery or tenancies in all the courts in the country. So it may be liquidation or may it be resolution. The whatever is important for the resolution or liquidation of the company, that must come to NCLT unless it is a matter of public law. Unless it is a matter of public law. So this is what is Embassy Property Development Private Limited. And the last issue dealt by with this Embassy Property Development is Section 65. The court, NCLT, and NCLT has powers to investigate into fraudulent matters. May it be fraudulent initiation of CIRP or the fraudulent trading transactions. And NCLT has the powers and also the powers to pass an appropriate order for contribution by the beneficiaries or by the persons who have done fraudulent activities. Going forward, it is Anand Rao Korada, a resolution professional versus Visha Fabric Private Limited. So in this particular case, while the order was passed for CIRP, the High Court ordered the auction of a property of the company. While the CIRP order was passed, I'm not sure whether the High Court was informed about the CIRP initiation or not. But yes, the High Court sold property of the company, asset of the company, which is under CIRP. So very simple, the Supreme Court set aside that order of the High Court. Supreme Court said that the code, like Section 14 of the code, prohibits the institution of suit, continuation of pending suits or proceedings against the CD, including the execution of any judgment, decree, or order in any court of law, tribunal, arbitration panel, or any other authority after the admission of application for initiation of CIRP. It also referred to Section 238, which gives an overriding power to the code over all extant laws. Also, Section 231 of the code was referred in this order, which bars the jurisdiction of civil courts in matters where the adjudicating authority under the code has power to pass an order. So considering this Section 14, the act of sale of asset by High Court, the order was set aside. It was only a single point order. Now, again, this issue of land and the issue of development of land again comes in. Municipal Corporation of Greater Mumbai versus Abhilash Lal. Municipal Corporation of Greater Mumbai versus Abhilash Lal. And the question was whether the provisions of the IBC code overrides the provisions of Mumbai Municipal Corporation Act 1888. And therefore, the resolution plan approved by the NCLT acquires primary rights, primary over all other legal provisions. Now, the facts of the case is that the appellant and respondent in this case is the municipal, the appellant is the municipal Mumbai Municipal Corporation, and the respondent is the CD, had entered into a lease agreement where the appellant lease the Mumbai Municipal Corporation Limited leased its property for 30 years, leased its land for 30 years to the respondent. And the respondent also availed some loan against the said land, because see, in most of the lease agreements, there is a clause for mortgage, and there is a clause for transfer of the leasehold rights. So based on these two clauses, the loan was given by the banks and the property was mortgaged. And when the default was there, the CIRP was initiated. The resolution plan was approved, and the resolution applicant somehow put some conditions on regarding the lease. And those conditions were beyond the lease agreement, which was originally entered into between Mumbai Municipal Corporation Act and the corporate debtor. Now the Supreme Court actually handled this issue although this section 238 was there, and Supreme Court said that this section 238, the overriding section of the code, shall not be applicable in cases where the assets of the CD are in question and not that of a third party. Now this asset belongs to Mumbai Municipal Corporation Act. It was leased to the corporate debtor for 30 years. The corporate debtor can be the management of the corporate debtor can be changed, but I don't think the COC or the NCLT has any powers to change the terms and conditions of that lease agreement. So the COC or the NCLT would not have any powers to change the terms and conditions of the lease agreement, which was executed by a third party. So that was the issue in this case. So all this Mumbai Municipal Corporation objected to it, and that the fresh interest in the property cannot be created. So it was held that the Mumbai Municipal Corporation would continue to control and regulate its properties the way it is originally mentioned in the lease agreement.
So just to once again to get your reflections,
yes.
When we are talking about IBC, they are talking about it has got an overriding effect on all other acts and statutes. So how does it come in this particular interpretation of the Apex Court?
Yes, Mr. Sridharan, your question is absolutely right. And the says that wherever any provisions of the law and the provisions of the insolvency code, if there is any conflict between the two provisions, then the provisions of IBC would prevail over the other law. Similarly, section 238 also says that if there is any instrument means any agreement or any document which has been executed between the parties, and that agreement is also having some kind of inconsistency within the IBC and the instrument, then IBC would prevail. No, the IBC says that when we talk about resolution plan, it talks about all the claims, creditors, which actually whatever can be done. Then the regulation talks about what all can be done by the committee of creditors under regulation 37, like haircut, the changing the terms, changing the security, but that all regarding the creditors or the claimants. Now, that all regarding the creditors and the claimants. That doesn't talk about the third party. Now let us talk about two separate things. Now, this one, the IBC deals with the financial stress of the companies.
Right.
It doesn't deal with the technical requirements. Now, think about a builder. The builder is constructing a building, and based on a license, there are hundreds of the requirements of the local authorities regarding the height, regarding the structure, regarding the sewage, regarding the light, regarding the security. So all these are technical requirements. So
Okay.
in case of any kind of non-compliances, these are not within the powers of the IBC to override everything. IBC can only handle financial disputes based on the assets of the company and the liabilities of the company. IBC cannot give you any kind of exemptions from the other requirements of the law that you would have to comply with for even constructing the building, for making a road, and also for abiding by the, because see, in that particular case, in the case of the Mumbai Municipal Corporation of Greater Mumbai, Municipal Corporation of Greater Mumbai, probably the resolution plan mentioned that the conditions of this paragraph would not be applicable, because see, maybe that the resolution plan says that one of the condition of the lease may be that it would be only used for the retail business, or it would be only used for the residential premises. So if somebody files a resolution plan that this particular clause of the agreement, lease agreement, would not be applicable, so that he gets the permission to construct a commercial building on it. So would that be applicable? Should that be accepted? No.
I think fair point, sir. Thank you. Thank you. Thanks for the clarification.
That cannot be accepted, right?
Yeah, got it. Thank you, sir.
Okay, I think coming back to this, another order which is very important is the Committee of Creditors of Essar Steel India Limited, and the through the authorized signatory with Satish Kumar Gupta. This is a landmark judgment, and it talks about the role of the resolution professional, and it says that the role of the resolution professional is administrative, and it is not the kind of adjudicatory. So administrative and adjudicatory, there is a difference, and whereas the role of the liquidator is adjudicatory. So now the role of the liquidator is adjudicatory, but the role of the resolution professional is only administrative in nature. He is responsible for keeping the company as a going concern. He is responsible for managing the affairs. He is responsible for protecting and the preserving the assets of the corporate debtor. And he is also responsible for taking control and custody of the businesses and the assets of the corporate debtor. Role of the prospective resolution applicants is that he will keep the company as a going concern. He must incorporate all measures which are necessary for maximization of the value of its assets, and the tenure and the implementation, everything he has to mention. So the role of the resolution applicant was also specified. Role of the Committee of Creditors was also specified, and it was supposed to be very powerful, that the commercial wisdom of the COC is upheld. They would take the decision based on the resolution plan, and the majority of the vote is very important. The role of the adjudicating authority and the appellate authority is also important. Judicial review by adjudicating authority must be within the sections of 30 subsection 2 and section 30 and section 32, read with section 61(3) of the code. Now the Honorable Supreme Court held that the adjudicating authority would only see the provisions of section 30, which talks about the minimum liquidation value which has to be offered to operational creditors, minimum liquidation value which has to be offered to the dissenting creditors, and that too in priority. Then the all the terms and conditions, whether there is a provision for management, there is a provision for supervision, the term of the resolution plan is clear, there is no condition in the resolution plan. So all these things are mentioned in section 30 and section 32 of the code. So the judicial review of a resolution plan is only restricted to this, and not that they are not supposed to renegotiate, they are not supposed to provide maximization of the value. That is something which is trespassing the decision of the majority of the Committee of Creditors, is not something which is the power of the NCLT. Then they're saying the secured and unsecured creditor cannot be equal because the secured creditor is a secured creditor, unsecured is an unsecured creditor, and the operational creditor is an operational creditor. So you can't say that everyone is equal in a resolution plan and everyone should be offered something to them and they should be considered on kind of equal footing. Then it also had that the committee of the constitution of subcommittees is possible, but the decisions taken or the recommendations of the subcommittee will have to be ratified in committee of creditors. So there cannot be a subcommittee which will approve the resolution plan. The subcommittee can be formed for some specific purpose, but that subcommittee would not have any power unless their decision is ratified by the committee of creditors. It also said very clearly the extinguishment of personal guarantees and undecided claims. The NCLT in its decision had extinguished the rights of the creditor against the guarantors once the resolution plan was approved. However, setting aside, the NCLT said that the personal guarantors would also be absorbed once the resolution plan is approved. That was set aside by the Honorable Supreme Court. The personal guarantors would not have any their rights would continue. So the claim submitted after the submission after the approval of resolution plan cannot be entertained. That was also part of this order. The profit the company is making during CIRP, that would not be distributed to the creditors. That would remain as the asset and property of the resolution applicant. Then this was the order where this even 330 days, when the amendment was made in section 4, the 180 days plus 90 days, 270 days, it was extended to 330 days in IBC Amendment Act 2019. It is for the first time, it was held in this case by the Honorable Supreme Court that this mandatory word is removed from this 330, and this mandatory is only directed because there may be circumstances where the corporate debtor would need some more time because of the resolution, because that is possible. So therefore the mandatory deadline of 330 days is also not mandatory. It is directive, and even time beyond 330 days can be used for exceptional circumstances. So these are this is the SR Steel India Limited. So a very important order handling, how many issues was handled by this particular order by the Honorable Supreme Court. So like any question from the participants, I would be very happy. It is only a question of time. Otherwise, I would be, I'm normally not get distracted by questions, and I would start again from wherever I would hold. So the understanding of these judgments are, I'm trying to again explain to you based on my own experience also. So in this judgment, Jayaprakash Associates Limited and others versus IDBI Bank, it was held in this order that if a resolution plan is rejected by COC, do that resolution applicant has power to submit a revised plan before the NCLT? And also whether the NCLT or NCLT has an inherent power to exclude any period from statutory period of CIRP. So in this case, it was held that no, the resolution applicant doesn't have any power to submit a revised resolution plan before NCLT. However, on the other part, that yes, NCLT and NCLAT, that powers as they are there, that they can extend under Article 142 of the Constitution, and they can extend the time for completion of the proceedings. So it does not touch the issue related to the powers of the NCLT, and NCLT exclude the time, but I understand that they have the power, but it was dealt with that question. the majority of the, but this was a case where the NCLT in fact intervened and kind of allowed another resolution plan, and the Honorable Supreme Court says that that was an exceptional case, but this particular case and this judgment may not be used as a precedent. So that means that the resolution applicant cannot submit a revised resolution plan in NCLT, and that is whatever was done by NCLAT was approved, but it was also said that this may not be used as a precedent. However, we understand that the NCLT and NCLAT has power to exclude the time limit, and because they've been doing it in various cases. This order of Supreme Court, Duncan's Industries Limited versus AJ Agrochem. This is only a very, very specific small issue because it was actually argued before this Honorable Supreme Court that under Section 16G of the Tea Act 1953, it is written that the no insolvency proceedings can be initiated without the consent of the central government. So this particular order specified that this Section 16G is only applicable when there is a tea undertaking or the unit of the company has been taken over by any other person, a body of person authorized by the central government. The court further held that the CIRP cannot be limited to the appointment of a receiver or winding up of a company, as the preamble of the court specifies the object is the revival of the corporate debtor. So all tea companies can be under the CIRP. The RP can be appointed, IRP can be appointed, liquidator can be appointed. So this Section 16 capital G of Tea Act would not be a hindrance. So that was maintainable. Sagar Sharma and others versus Phoenix ARC Private Limited. And this was a case of Limitation Act on the Article 137 of the Limitation Act. And it was held by the court that Article 137 of the Limitation Act would be applicable on all applications filed under Section 7 of the code. While it was also said that this is not considered to be the enforcement of security interest, where the time limit under the Limitation Act is 12 years. So it is said that this is not an application for enforcement of security interest, where the time limit is 12 years. It is a case of resolution. So therefore, Article or Section 137 of the Limitation Act would be applicable, and the period of 3 years would be applicable and not the period of 12 years, because this is not an application. Application under Section 7 is not an application for enforcement of security interest. Now, I would give you an illustration. Wherever a secured creditor is likely to enforce the security interest, then there is a time limit of 12 years under the Limitation Act. So that 12 years is not applicable to an application under Section 7 of the code, but only 3 years are applicable. So another application, which is Jignesh Shah and others, this Jignesh Shah and others is also on Limitation Act. This particular says it because this was on the financial debt. NCLT admitted the claim as a financial debt after analyzing Section 5(8) of the code, and the tribunal in its judgment concluded that financial debt has two aspects. One, it is disbursed against time value of money, and the amount raised has any commercial effect or economical gains. Therefore, in the present appeal, Supreme Court is made by this appeal was made by the shareholders of LaFin. LaFin is again a I think financial company against the orders of NCLT. The petitioner did not question the facts of the case, rather contended the statutory bar of limitation against ILFS. The court set aside the orders of NCLAT and NCLT on the ground that the Limitation Act 1963 would apply to all applications made under Section 7 of the code, as the winding up petition before the High Court was filed beyond a period of 3 years from the date of cause of action. Therefore, the same cannot be proceeded with. So the application under IBC was within the limitation period, and whereas the application which was for winding up, that was beyond the limitation period. So this was in the Jignesh Shah. It was on the however, all these basic orders of Limitation Act, some like in the Limitation Act, I have a detailed research on this Limitation Act. There are various sections under the Limitation Act where this period of 3 years is condoned, or it is some period is excluded. So when you talk about recently, Section 18 of the Limitation Act is applicable to IBC. Section 14 of the Limitation Act is applicable to IBC. Section 12 of the Limitation Act is applicable to the IBC. All these judgments are coming which are dealing with one or the other component of Limitation Act. So I think we read the first judgment which says that this particular the limitation law applicable to IBC is Section 137, and the limitation period would be 3 years and it would not be 12 years. On other cases, now this particular Jignesh Shah says that the application made under Section 7 of the code, the limitation law would be applicable, and the winding up petition before the High Court was filed beyond the period of 3 years from the date of cause of action. Therefore, the same cannot be proceeded with. So in this another case of limitation, which is Gaurav Hargovind Bhai Dave, Gaurav Hargovind Bhai Dave versus Asset Reconstruction Company, India Limited. This was an appeal out of an assigned debt, which was declared NPA in the year 2011, and the proceedings against it was initiated in DRT. In 2017, the respondent initiated CIRP against the petitioner, and NCLT admitted the application applying Article 62 of the Limitation Act. On appeal being dismissed by unclear, the matter was preferred to Supreme Court. Applicability of the Limitation Act in case application filed under Section 7, it was held that Article 62 applies only on suits and only on the suits, and the present case being an application under Section 7 of the code would fall within the residuary Article 137. The limitation period will start from the date on which the default occurred. Since the period of 3 years had elapsed from the date of declaration of the debt amount as an NPA, the application is time barred. So in this order, it was held that the filing of application for recovery under DRT, which was filed in 2011, and the judgment arrived in the year 2016, but there was no recovery. But in 2017, the CIRP application was filed. So in this case, it was held. In this case, it was held that the application that was filed before DRT, that cannot be considered as the period which should be excluded. Period of 3 years starts from the date of default, which can be considered as date of NPA also. So therefore, this application, Gaurav Hargovind Bhai Dave versus ARC, that was time barred. So now what I'm concluding out of this order is that the period between 2011 and the period of filing of the application under Section 7, that is 2017, that cannot be excluded. That cannot be excluded because, see, the Limitation Act says that if proceedings were continuing in a court which does not have jurisdiction, that period would be excluded. Limitation Act says that in case any proceedings were going on in a court which doesn't have jurisdiction, that would be excluded while we calculate the number of years for the purpose of limitation law. However, the proceedings before DRT or that definitely was the right court. It was not an incorrect court or incorrect jurisdiction. So that cannot be excluded for the purpose of limitation. I hope it is, I'm clear enough. Okay, see now going forward, we have this Pioneer Urban Land and Infrastructure Limited versus Union of India. Again, a landmark judgment on the constitutional validity of Section 5(8)(f). Section 5 is a section of definitions. Section 5, subsection 8 is a section of financial debt, and subclause F deals with a scenario where any advance has been given. Any advance has been given to another person for forward purchase or sale of any good. So when we talk about this home buyers case, they give advance to builder for the purpose of purchasing a property. So this particular section is applicable for any kind of advances. As an illustration, like suppose a company places an order for constructing a sugar plant or a chemical plant or a steel plant to another company, and also makes a payment which actually would be used by the manufacturer of plant as an advance. And in case that particular plant is not delivered by that manufacturer, then this company who actually have placed the order, that company can file the application under Section 7, because this company who has given advance would be considered as a financial creditor under Section 5(8)(f). The same logic applies to home buyers. Home buyers have given advance to a company to purchase a flat. So Section 5(8)(f) was applicable. And in this 5(8)(f), when this it was considered as a financial creditor, that was only clarificatory. Section 5(8)(f) was originally there in the code. Allottees, it was only a clarification which was added in the IBC, and that was also retrospective. So in this case, the Supreme Court referred that the Insolvency Committee report, which deliberated that if forward sale or purchase transactions are structured as a tool or means for raising finance, there is no doubt that the amount raised from the allottees would fall within Section 5, subsection 8, clause F of the code. It further highlighted the difference between the real estate developers and the operational creditors on the following grounds. Because see, in this, all the lawyers were kind of arguing that the operational creditor also supply goods or services, and also everyone was taking so it was said that the operational debt in a person supplying goods and services is a creditor, which is exactly the opposite of the real estate projects. And it was also held that the operational creditor has no interest in or stake in the corporate debtor, while the allottee is virtually concerned with the financial health of the corporate debtor. In an operational debt, there is no consideration for time value of money, but in real estate project, the money is raised from the allottee against the time value. So it was held by the Apex Code that the home buyers are financial creditor. They are just like an individual debenture holder or fixed deposit holder, and this particular amendment does not amount to infraction of Article 14 of the Constitution of India. So this was the judgment of Pioneer Urban Law and Infrastructure.
Sir, once again, quick intervention here. While the judgment is there for us to go with, and then the facts being clearly found by the Apex Code. Once again, just for a quick reflection, don't take too much time. How can we really categorize in an abstract way that home buyers are coming under the financial creditor? So what is your use? Quick reflection, sir. I don't want to take much time.
So, like anyone who has given any loan to a company, that is all is a financial debt. Now, when the definition of operational creditor was made, like anyone who actually is supplying goods or services to a company would be an operational creditor, whereas anyone who is giving an advance to purchase anything from a company, that he has not purchased anything, he has not sold anything, but he has just given some money so that he should get his product or service. And why he's given that advance? Because that also will work as a working capital for the manufacturer. No, when
Great,
we
sir.
take, when we
Okay,
take,
let me add one more dimension.
yes,
Supposing I am paying for raw material purchase 100% advance,
yes.
then in which case, what would be the impact of this particular observation by that?
No, in case you are paying for the raw material as 100% advance to Steel Authority of India, and the Steel Authority of India is not delivering the goods to you as per the purchase agreement, as per the purchase order. No, in case the Steel Authority of India was, in fact, they agreed that they would give you the material within 60 days. So on 61st day, Steel Authority of India has defaulted, and you have a right to file an application under Section 7, as you would be considered as a financial creditor and not as an operational creditor, because you have not sold anything to Steel Authority of India. You have given some amount to Steel Authority of India, which actually is being used by Steel Authority of India for their own operations, for their own working capital.
Okay, thank you, sir. Thank you.
Yeah. So the Bikram Chatterjee versus Union of India is also a very, very important case. Because this was the case of Amarpali group of companies, and in my profile you might have also read that Amarpali group, it's a multiple companies case. It is the largest real estate developer in northern India, having more than 40,000 home buyers, allottees. The out of like 4 or 5 main companies of this group, which was under insolvency, the 3 companies were with AAA insolvency. So the 3 companies were the largest companies of Amarpali Group, and then when the home buyers filed a writ petition before Supreme Court, and they wanted kind of a resolution through the Supreme Court for the purpose of experimenting, took up this case for the resolution, and they started doing the resolution for this case under the supervision of the Supreme Court. I am not saying that this particular case was exactly under the insolvency law. This particular case was not kind of understanding there was no usage of the liquidation value due to secured creditors, liquidation value due to dissenting creditors, liquidation value due to operational creditors. Section 53 priorities was not used. So this was the powers with the Supreme Court, that this case was handled by Supreme Court, and a lot of insolvency law provisions were not used. The questions before this court was, whether the claim of the bank due against loan where the leased land was mortgaged and the authorities lease dues on the corporate debtor are valid, whether the registration of the corporate debtor under RERA is liable for cancellation, whether the relief can be provided to the home buyers. The Supreme Court held multiple things in this case. One, that the authorities, when it is calling authorities, means the land development authorities, like in this case Noida, Greater Noida, they were the development of the colony, development of the city. So these authorities, they were also supposed to keep the track of the project's development. They failed to keep a track. The builder kept on cheating on the allottees. The builder did not pay the dues of the leased land to the authorities, but continuously took the money from the allottees. So this was also said that this is also the responsibility of the authorities. So whatever fraud has been done with the allottees, the authorities, the land development authorities, are equally involved in that. The second thing that the Supreme Court held, that the banks were also negligent in sanctioning the loan, because they did not read the condition mentioned in the lease that the NOC would be taken from the authority, the land development authority. NOC would be taken, and the NOC would be given only after the full payment of the premium is given to the full premium is given, or the annual lease rent is paid to the authority. So the Supreme Court said that the banks also they also worked with a lot of negligence. They did not read the meaning of the NOC. So therefore, the principles of fraud vitiates it attracted, and it becomes the duty of the court to protect the home buyers. What this court says, that the authorities, the land development authorities, who are now claiming that the dues against their land and the leased premium is due from the company, so they would maybe that they cancel the lease, or they would not allow the banks to hand over the possession, or they would not allow the builder to hand over the possession to allottees. That is not presently applicable. Similarly, the banks also were negligent. So it's basically a fraud was vitiated. A fraud was done with the allottees. So the Supreme Court therefore took the driving seat, and the first and foremost objective of the Supreme Court in this case was to protect the home buyers, and everything else was later. So presently also in this case, Bikram Chatterjee case, everything is being protected, like home buyers are being protected. The entire money, resources, whatever is available, that is being spent on the construction, and the RERA is not allowed. RERA is not allowed to cancel the project. The banks are not allowed to take over the possession. The authorities, the land development authorities, or the lessors of the land, they are not allowed to take over the land, even if their dues are not being paid. So I believe these few things that I'm saying, but this doesn't mean that these are the provisions of the IBC, but these are the way found by the Supreme Court, the rationale found by the Supreme Court, that the fraud which was done with the allottees, everyone was involved. So therefore, the primary responsibility objective of this is to protect the home buyers. Next Supreme Court order is J.K. Jute Mill Majdoor Morcha versus Jagilal Kamlapat Jute Mills Company Limited. So this was the trade union would be considered as operational creditor for the purpose of IBC or not. The fact is that the appellant had issued a demand notice to the respondent under Section 8 of the IBC against dues owed to the workers, to which the respondent had replied. NCLT dismissed the application made before it on the ground that the trade unions were not covered as an operational creditor. NCLAT upheld the decision of NCLT. The Supreme Court held that the registered trade union can sue and be sued under the Trade Union Act. And trade union, being an entity established under the statute, is a person under Section 3, subsection 3 of the Code. Further, Form 5 under Rule 6 of the IBC clearly states that an application can be filed conjointly. The fund of the trade union comes from the collection of the workmen who are its member, and this fund can be utilized to protect the rights of its member in case of disputes with their employer. Thus, a registered trade union is admissible to make an application under the code on behalf of the workers to whom the corporate debtor owes in place of services rendered by them as an operational creditor. So very single concept that the trade unions also collectively can file an application for the insolvency of the company because the application otherwise can be filed jointly. So a trade union would be considered as a joint action of the workmen and employees for filing an application against the company. Single issue. So this Dharni Sugar and Chemicals Limited versus Union of India, it is a different issue. It is absolutely not under the Insolvency and Bankruptcy Code. It actually deals with Section 35AA and Section 35AB of the Banking Regulation Act. So this was triggered when the RBI issued a circular dated February 12, 2018, and it was incorporating the revised guidelines for resolution of stressed assets. So if you recall, the RBI gave a circular dated February 12, 2018, and in that, as per that circular, all the existing schemes of restructuring of the financial debt, like CDR scheme, the S4A scheme, all these schemes were completely abolished, and a new circular was issued dated 12th of February 2018. And as per the new circular, the intercreditors agreement would be executed between the lenders, and a resolution plan would be submitted by the corporate debtor based on the RP4 rating. And in case the resolution plan is approved by all the creditors in a meeting, so that that is what was considered to be a restructuring plan. However, also the powers of Section 35AA of Banking Regulation Act was used, and it was directed that the banks uh, would undergo this kind of restructuring mandatorily, and it was applicable to all having outstanding facilities of more than 2,000 crore. However, the Supreme Court said that this is although like working on the individual companies or working on the individual cases after taking the authorization from the central government, but you cannot issue a general circular without the authorization of the central government. So that particular circular was struck down, and after that the modified circular was also issued, and that was, I think, 7th June 2019. So that was the circular after this court, and in that particular court, it was not, in that circular it was not mandatory, but it was optional. So this is one order. Jai Balaji Industries Limited versus State Bank of India. Then in this particular case, it is basically a case of natural justice. So it was in March 2019 that this was a case where this natural justice was upheld to be of primary importance. So natural justice includes that the notice has to be served on the other party. It was referring Rule 48 of the NCLAT rules, where the notice to the other party is very important, regardless that this advance copy was given to the other party. But the court said that the principles of natural justice are applicable. The notice to the other party has to be given, and if the notice to the other party is not given, the CIRP proceedings are likely to be quashed. So this is what the order was. It was only on one point: Jai Balaji Industries Limited versus State Bank of India. The next is Reliance Communications Limited versus State Bank of India. So this was a case where you probably recall that the Mukesh Ambani kind of saved Anil Ambani and gave 250 crore check to Ericsson, and the total claim of the Ericsson was 1,100 crore from Reliance Communication. So then the Reliance Communication Limited was supposed to go through CIRP. For the protection, it was settled in the court that the amount would be paid. 250 crore was also paid. However, the balance amount was not paid, and some understanding, some kind of agreements, and finally this case went up to Supreme Court, and the Supreme Court observed that there was disobedience of the order. There was an order by NCLAT, and also there was a disobedience of the order, which must be regarded is the letter and the spirit of the order, together with the bona fide or genuine belief of the alleged contemner. So in the instant case, the act of petitioners amounting to hampering the administration of justice and took cognizance of such conduct on the part of petitioner, thus a penalty of ₹1 crore on the petitioners, along with the remaining dues to be paid within a week of the order being made, failing which they would have to undergo an imprisonment of 3 months. So 1 crore penalty, the remaining dues, 1,100 crore minus 250 crore, that was supposed to be paid by Anil Ambani to Ericsson, and that was supposed to be paid within a week's time. Otherwise, the contemner, who was Anil Ambani in this case, would undergo an imprisonment of 3 months. That was the order of Reliance Communication Limited. So this is based on the powers of the NCLT, NCLAT regarding the contempt. So this was order regarding that. We have now the case Sassidhar versus Indian Overseas Bank and others. Case Sassidhar is also an important order. It was on dissenting financial creditors. In this case also, the role of the NCLT, role of the NCLAT was defined. And it was also said that the role and scope of NCLT is not beyond Section 30 or Section 32 or Section 60, subsection 3. So this 66% voting cannot be compromised, even if it was 65% in favor of the resolution plan, but that cannot be compromised. 66 is minimum, and the NCLT or NCLAT doesn't have any power, even for the purpose of maybe keeping the company as a going concern, workman, whatever may be the objective, but that is not within the power of the NCLT. So the legislative intent is also upheld, like the minority dissenting financial creditor that must prevail, and if it is not less than the specified percentage. So therefore, the interest of the dissenting financial creditors has to be protected. Approval by 66% of the voting shares of the financial creditor is strict, and it cannot be liberalized. It also says, K. Sassidhar versus Indian Overseas Bank also say that the COC wisdom is paramount. The commercial wisdom of the COC is very, very well paramount. It doesn't have any scope for judicial intervention. The intrinsic assumption is that the financial creditor is fully informed about the viability of the corporate debtor and the feasibility. That is assumed. So that is the reason now whenever we talk about any resolution plan, it is assumed that the COC, or it is considered that the COC's duty is to see whether the resolution plan is viable, whether the implementation is practically possible, whether the financial viability and the feasibility is there or not. So that is all within the powers and the duties of the Committee of Creditors. And as I said earlier also, that the changes in some of the law, like Section 14, it was a clarification. When I said that Section 14, it was regarding the license and all that. And the reducing the qualifying standards, the Section 30, subsection 4, it was also retrospective. Section 239A amendment was also retrospective. So then coming to the role of other invitees, Vijay Kumar Jain versus Standard Chartered Bank, the role of other invitees in the Committee of Creditors. Now, who are the other invitees? The first is like the operational creditors having an outstanding which is more than 10% of the total debt of the company. So they are one participant, they are one invitee in the COC. However, they are not the members of the Committee of Creditors. So this particular judgment, Vijay Kumar Jain talked about the other invitees or participants of the COC meetings, and they are not members of the Committee of Creditors. So the Supreme Court held that the resolution plan should also be given to the operational creditors. All other documents whatsoever is being circulated to other members of the Committee of Creditors, all those documents should also be circulated to the invitees. However, when we actually see the sharing of the summary of the valuations of the assets of the company, it is very clearly said that it would be shared with the members of the Committee of Creditors after they provide a confidentiality undertaking. So therefore, this particular judgment is not applicable to, so Vijay Kumar Jain versus Standard Chartered Bank is not applicable to, hey, कैसे हो गया? So the Vijay Kumar Jain is not applicable to the one operational creditors who are invited, and also the members of the board of directors, the directors. It will also not be applicable to the members of the board of directors whose powers are suspended. So the powers of the board of directors have been suspended, but all the directors of the company would continue to be called as director. So they are also not supposed to be called as suspended director. They are supposed to be called as directors of the company. I have seen most of the RPs or people, they are always saying that they are suspended directors. No, nobody has suspended them. They are still directors of the company. Nobody can tell them that they are ex-directors of the company. Nobody can tell them that they are ex-managing director of the company. They are managing director, they are directors of the company, but board of director doesn't have any power. So the director can function through board of directors. Director gets delegation of powers from board of directors. So when the board of director is not functioning, the board of director is suspended, then there is no power with the directors. No power, even those powers which has been earlier delegated to directors, maybe a finance director, maybe a managing director, all those powers which were delegated by board of directors earlier, all those will also stand void, since the powers of the board of directors are suspended. So we call them as director, we call them as managing director, but their powers of the board of directors is suspended. So they have all the rights. In fact, the observation of the court was that they don't come to meeting for just having a cup of tea. They come to meeting for understanding the decisions being taken for their company. Whatever documents are required to be circulated, all those documents would be circulated to them. So that's what is the order of this. So very important, I think this may be the last because of the timing, because other speakers might even be joining. And for rest of the orders, I would be sharing my PPT, and I would in fact update my PPT in a day, and I would be circulating with all of you. It's not really the PPT which is important. In fact, in case you would have asked more questions, that would have been more beneficial to all. But I think the Swiss ribbon is also very important. This is the constitution of NCLT, and NCLT is constitutional. It was upheld. That then the scheme of law distinguishing between the financial creditor and operational creditor was also upheld in Swiss ribbon. The operational creditor did not have any right of vote. That was also upheld. The differential between operational creditor and financial creditor was also upheld. It was considered as fair and equitable treatment, like as per the regulation 38. The information utility notings are only prima facie evidences, and the same may be rebutted. It was also held that the section 12A, which is for the withdrawal of the applications, that is also not violative of Article 14. So the section 12A can be invoked with the 90% voting. It is also said that the COC under section 60 doesn't seem to have the last word. NCL and NCLT or NCL80 would look into the compliances, legal compliances of the resolution plan, the process which is supposed to be conducted by the RP and the COC, that also would be seen by the NCLT and NCL80. It is only the commercial wisdom where it is the power of the COC. Section 29A is also retrospective, that this is also, so resolution plan is considered to be a reorganization. In this particular order, one important factor was mentioned, as far as the related parties are concerned. And the categories of related persons in section 29A have to be read that is having same flavor with the explanation 1, and if so read, would include only persons who are connected with the business activities of the RA. So you probably might have seen recently that the companies of Anil Ambani is being taken over by Mukesh Ambani, and they are not considered to be the relatives because the relatives would include only persons who have connected with the business activities of the resolution applicant. So since it is publicly known that they both are not doing business together, so that was not considered to be the related party. So judiciary has a minimum role. Section 53 was also upheld. The powers of the RP as against the liquidator was also defined. The RP is only a facilitator. Liquidator does not work under the COC. That was held in Swiss Ribbon. That the liquidator is independent and the liquidator doesn't work under the COC. RP has been given the administrative powers and not quasi-judicial power. Liquidator who determines the claim is given quasi-judicial power. Other directions, of course, is not important for us. So I think to the organizers, I have to just now say that maybe that the other speakers are also there. What do you guide me? Because I continuously try to develop on various orders, and the time given to me is up. I can continue, or maybe that there is another.
Please, 5 minutes, sir. You can conclude in 5 minutes.
All right. So this Rajputana Properties Private Limited versus Ultratech Limited, in this order, in this case also the NCLAT order was upheld. The approval of NCLT is not a mere requirement formality, although NCLT is not permitted to alter the terms of the resolution plan. Ultimate authority to approve or reject a plan vests with the NCLT, and for that it should consider the following aspects. I have already said that the NCLT's power is only to look into the requirements under section 30, subsection 2, and now also like other amendments under section 30, subsection 4 also, whether the plan is fair and equitable and there is any unjust discrimination not envisaged in law, whether the plan adheres to the objects of the code, that is maximizes the value of assets and balances the interest of all the stakeholders. Only if the aforesaid questions are answered in satisfactory, the plan is confirmed by the NCLT, and otherwise the NCLT may deny the confirmation of the plan. Transmission Corporation of Andhra Pradesh Limited versus Equipment Conductor and Cables Limited. Like this is very old judgment. Honorable Supreme Court quashed NCLAT order threatening the appellant to CIRP initiation. So that was not taken very right. Brilliant Alloys Private Limited versus S. Rajgopal and others. Withdrawal of CIRP under section 12A read with regulation 30A. The stipulation in regulation 30A is withdrawal not to be allowed after inviting EOI is only directory depending upon the facts. So the Brilliant Alloy Private Limited, the 12A was done even after the, see this was also amended later on. This presently the 12A can be invoked at any stage even after the invitation of the expression of interest. So based on this, there was an amendment. There was a kind of amendment in the law. Then is the BK Educational Services Private Limited versus Prague Gupta and Associates. The Limitation Act is applied from the inception of the code, and that's not something which came later. Although the amendment came later, section came later, but then it is applicable from the inception of the code. ArcelorMittal is another good order. ArcelorMittal India Private Limited versus Satish Kumar Gupta, and this is regarding section 29A, see-through provision and de facto provision, Act acting jointly does not mean a joint venture necessary. It is in the sense of acting together. Stage of ineligibility attaches at the time when this resolution plan is submitted by a resolution applicant. Management ordinarily vest in the board of directors and include MD, manager, and the officers. Expression control was also defined, the 29AF, if a person is prohibited by a regulator of the security markets in a foreign country from trading in securities or accessing the securities market, the disability under subclause would attach. ArcelorMittal further says the timeline specified in the IBC are mandatory and cannot be extended. Model timelines are as provided in Regulation 40A is to be followed as closely as possible by all authorities. Appeal against order approving a resolution plan has to be only on the grounds provided under Section 60, subsection 3. Appeal against the order of rejecting a resolution plan would also lie under Section 61 only. Time utilized for proceedings must be excluded from the CIRP period. Challenges at various stages, that was also handled by ArcelorMittal. Resolution applicant cannot challenge the report of the RP under Section 30, subsection 2, rejecting the resolution plan. It is to be noted that the RP is only required to confirm the completeness of a resolution plan and not to take any decision. As regards the conformity of the resolution plan with all applicable laws, the RP is only required to give his prima facie opinion to the Committee of Creditors that applicable law has not been contravened. Section 20, subsection 2, clause E, read with the Regulation 36A, is clear that the RP need to decide. Need to decide. He just need to give his due diligence report. RP need not to decide. He just need to give his due diligence report to COC for each eligible resolution plan. A resolution applicant cannot challenge the decision of the COC in case the plan could not garner 66% of the voting share. Role of NCLT is again jurisdiction to enter or dispose of any application or proceeding by or against the corporate debtor or corporate person. Does not invest the NCLT with the jurisdiction to interfere at an applicant's behest at a stage before the quasi-judicial determination made by the adjudicating authority. NCLT is the sole authority for applications and proceedings by or against the corporate debtor covered by the code. No other forum has jurisdiction to entertain, dispose of any such applications or proceedings. This was ArcelorMittal. So I think we can conclude now. I think otherwise we may continue, but then I am sure that I would be able to give you the PPT. So over to organizers. So yes, Mr. Rao.
If you have any questions, please ask quickly. We have very less time. If any of you have any questions, please ask.
So thank you very much for your valuable time sparing with us to the Guntur branch, and thank you very much, and we wish all good health. Okay, thank you, sir.
Thank you very much, all the participants, and thanks to the organizations, the Guntur branch of ICAI. I think this is a good endeavor that you are conducting this kind of programs for fellow chartered accountants, professionals, and thank you participants for listening to me, and I look forward to have such opportunities in future. Thanks a lot. Thank you, everyone.